Well, good afternoon. My name is Sulee Clay, and I'm going to be doing a presentation today on Virginia Cannabis Licensing 101, mostly going over what the statute provides and what we can expect to find as we move forward in the process. Hopefully, those of you who have joined us today are interested in learning more about winning a license, and my goal is to give you as much information about that process in Virginia as I can. By way of introduction, I'm a partner at the law firm of McKinnon, Shelton and Henn, and I'm a corporate attorney. I do work for a lot of companies and a lot of businesses, but with a specialty in cannabis. And I am going to have a presentation here where we go over initially some of the definitions that we find in the law and also some practice tips to help you all navigate this process. So please join me in taking a look at the definitions that are contained in the code. These are the important ones that we think we should bring to your attention at this time. I think it is important to note that the legislature in Virginia enacted the Act, which is what we are calling the Virginia Cannabis Control Act of 2021. That act has a lot of high-level requirements, and it authorizes these various entities that it creates to move forward with writing regulations under the Act. And those regulations are going to have all of the details associated with the licensing and approval and enforcement processes. Until those regulations are written, we don't know exactly what the details will be. But the purpose of this presentation is to let you know what the law says at this time. And like I said, a lot of those points are still high level and still need to be fleshed out. So with no further ado, the authority is what's being created by the Act, and that is the Virginia Cannabis Control Authority. The Cannabis Control Authority will be managed by a board of directors, which we are calling in the Act the board. The purposes of the board are to write the regulations under the Act, to control the sale and transportation and delivery of cannabis products in the state, to grant, suspend, and revoke licenses, and to ultimately establish a cannabis business equity and diversity support team, which is going to focus heavily on issues related to ameliorating the disproportionate impact that the war of drugs has had on certain Virginia communities. For support for that community, the Act does provide for the fund. The fund is a business loan fund that will loan funds to qualified social equity applicants. The details of the fund and how that will work are yet to be determined. But that will be a pool of capital which will be set aside to assist social equity applicants in starting cannabis businesses in Virginia. So that is a progressive item in the law that has not been done in many other places. And so Virginia is going to be a bit in the forefront of rolling out a program like this. The program itself is called the Virginia Cannabis Equity Business Loan Program. And they will partner with a CDFI, which will manage the fund. And a CDFI is a community development financial institution in the community, and they will choose a particular Virginia CDFI to manage the loan fund program. So those are those definitions. Going into some detail on these definitions, the Cannabis Business Equity and Diversity Support Team has the following purposes. They will be working to develop a diversity plan and other requirements for individuals that be allowed to possess more than one license category. And we'll talk about this a little bit further below. This is an important facet of the law in Virginia that's different elsewhere. They do not allow vertical businesses except in certain limited circumstances. So we'll talk about that. The CBDST, as I'm calling it here, will also analyze industry barriers that make it difficult for disadvantaged businesses to succeed in the marijuana industry. They will be providing business planning assistance. They'll be spreading awareness, technical assistance, and doing other outreach events. And so it'll be important, if you are interested in applying, to pay attention to the programming that this team puts out. I imagine that they will have a variety of training sessions once the application is published, and will try as much as possible to assist connecting folks so that they can have successful efforts in the state of Virginia. I think it's important to note really up front that Virginia is going to be a competitive process, and therefore, much like if you were bidding for competitive grants or other competitive bids, you will be required as an applicant to put together a proposal that will be evaluated by a designee of the authority and awarded points, and succeed or fail based on how well you execute in that effort. So we'll be talking a fair amount about that today. Okay, moving on. The Cannabis Equity Reinvestment Board is another creation of the Act. And similar to what you saw previously, it has a list of purposes that are very focused on remedying disparities in the communities that have been historically and disproportionately targeted and affected by drug enforcement. So they will be implementing scholarship programs. As we mentioned, they'll be administering this loan fund, and they'll be collaborating to try to pursue the policies and goals of diversity and inclusion. They will also be reporting annually on their success or failures. Interestingly enough, the CERB will be comprised of 20 Virginia citizens appointed by the legislature and the governor. And this list here shows how that committee must be comprised. And as you can see, they seek to have folks that are expert in a variety of areas that are important to rolling out a diverse and community-oriented cannabis program. You may also note that the Virginia law does specifically call out historically Black colleges and universities as being involved in the process. And as we'll see in a further slide, having attended a Virginia HBCU can qualify you as a social equity applicant. So discussing the fund itself, the Act has determined that they will set aside 30% of all tax profits from the industry to fund this fund to pursue, as I mentioned, the attempting to address the disparate impact of economic disinvestment and disproportionate enforcement of drug laws in certain Virginia communities. Those communities will be designated in the regulations by the authority. So we do not know exactly where those areas are, but we will find out. The fund will also provide technical assistance, scholarship opportunities. They will work on workforce development programs, and they will use funds to contribute to the Virginia Indigent Defense Commission, which helps offenders, and also the Virginia Cannabis Equity Business Loan Fund. So this is a big, important question that folks have been working on, I think, for some time, which is how exactly does the law define a social equity license applicant? A social equity license applicant in Virginia will be someone who has lived in Virginia for at least 12 months and for which one of the following 3 items is true. At least 66% of the owners have been convicted of a marijuana violation. 60% or more of the owners have resided for at least 3 of the past 5 years in one of the areas that the authority determines to be disproportionately policed for marijuana crimes or economically distressed, again, areas that are TBD, or 60% or more owned by persons who graduated from an HBCU located in Virginia. Now, currently, the law is not clear on how you might be able to mix and match these categories, or whether if you are an entity, that means you need to have been in existence for at least 12 months. But the details on this will be fleshed out in the regulations that are to come. So currently, the legislature is working on the regulations. And, we have some sense of where they're headed, but the devil is always in the details. So we still do not know exactly how this will be implemented. But this will be an incredibly important designation. I imagine a lot of the folks on this call are hoping to qualify as social equity applicants. And it's imperative that you nail it perfectly in terms of your ownership structure. The law will look behind and see if perhaps you are a front for someone else. There are other items that will cause you to be disqualified if this is not very clean and straightforward and clear. So we will talk a bit about this, but it is so important that when you apply, you get every point on an application, and a lot of points I assume will be awarded for being a social equity license applicant. In addition, we don't know all of the benefits yet, but the typical benefits include points. They include possible head start on licensing and filing. And it's possible in Virginia that there may be some micro or small business vertical licenses that are permitted for social equity licenses. So we don't know yet, but we do know that being a social equity license qualified applicant is going to be an important factor in winning a license. So the law sets forth 5 different types of licenses, which we've set out here along with the code sections where they can be found. There is not a lot of detail in the law right now regarding these various licenses in terms of what are the requirements and what will the application look like. That will all be set forth in the regulations once those come out. But as of right now, we do know that there will be marijuana cultivation facility licenses, manufacturing facility licenses, testing facility licenses, wholesale licenses, and retail licenses. And we'll talk a little bit about each of those categories so you can have an understanding of exactly what you can do with the license. So the first one, a marijuana cultivation facility license, is going to allow the licensee to cultivate, label, and package retail cannabis, sell marijuana to licensed retailers, and sell immature plants and seeds directly to consumers. Interestingly enough, in a way that makes Virginia different than other states, there are 2 types of licenses, a Class A license and a Class B license. The Class A license is going to be the traditional license that you think of if you are a marijuana grower or producer. The Class B license is going to be for growing marijuana with Delta-9 THC of up to 1%. 1% is not the cannabis that you're thinking of. 1% marijuana or cannabis is really, I'm calling it hot hemp. It would be hemp if it were below 0.3% Delta-9 THC. So this is hot. It's not hemp. It's cannabis. And so because of the conflict with federal law, which says that hemp has to be below 0.3% THC, Virginia has created a license category to benefit its hemp farmers by allowing unlimited Class B licenses to anyone who wants it to grow hemp up to 1%. So this is not what folks are smoking to get high or in the traditional sense of the cannabis business, but it is cannabis, and it is otherwise prohibited under federal law if it's above 0.3%. So this creates a benefit for Virginia hemp farmers to have some latitude in the types of plants that they could grow. So the Class A licenses will be limited, meaning they'll be competitive, competitively bid, and the Class B licenses will be unlimited and really just for hemp farmers. All right. The other types of licenses here we'll summarize briefly. We have the manufacturing facility license, which allows the licensee to manufacture, label, and package retail marijuana to licensed retailers. So this license is what you need if you got a great brand idea and you want to make a cool gummy or, you know, some other type of concentrate. It is the producer, the manufacturing facility is who takes your cannabis flower and turns it into oils and other products that can be branded and marketed and sold in retail facilities. A marijuana testing facility is for a lab that tests for potency and pesticides in marijuana products. All marijuana products are required to be heavily tested. And so a testing facility, you know, to the tune of whatever it is, $50 a test, can go into business assisting the industry in the manner of testing. A wholesaler license is for someone that's not a manufacturer, but not a retailer, but who wants to be able to buy and resell. So the wholesaler is going to be in the line of a distributor license. This is a license that doesn't exist in a lot of other states. It does exist. And, you know, it will be where we will find the distributors of marijuana products. In retail, speaks for itself. A retail licensee can operate a store to sell products directly to consumers. As of now, there's no specific delivery license or other types of licenses contemplated. Of course, that could change, but at least in terms of this first go at the act and the regulations, these are going to be the licenses that are available. All right, so the no vertical rule. So this makes Virginia different, not from everywhere, but from a lot of places. And it also, I guess, is really a effort at pushing diversity and inclusion, because with a no vertical rule, no person can own more than one, can have an interest in more than one type of license. And so that means if you own a cultivation facility license, you cannot be a manufacturer. If you're a manufacturer, you cannot have a store. Verticals, which in the industry are considered the holy grail, are folks that hold the full gamut of licenses in a given state. So someone that has a cultivation license, a manufacturing license, and a retail license. If you have those things in a given state, you are considered a full vertical. And as I said, it's the holy grail. It's what everyone is trying to be. So Virginia is prohibiting that, except in certain limited exceptions. And hopefully they'll be limited. We'll see. But right now, the existing pharmaceutical cannabis processors can be vertical. So they can apply for other licenses, other types of licenses, giving a huge advantage to existing folks in the market. And also industrial hemp producers can get a vertical license, which is interesting. However, they have to pay $1 million to do it. And they have to have an approved diversity and inclusion plan. So it'll be interesting to see how that fleshes out in terms of who's able to take advantage of those designations to obtain verticals. Whoever does is going to have a competitive advantage in the market. So if there is an opportunity for social equity applicants to own a full vertical, which the law implies may be found in the regs once they're published, then that'll be an interesting license category, which would be a social equity applicant owned full vertical. All of these cultivation licenses may be capped at size. We don't know for sure what the sizes will be, but there will be size limitations more than likely on these, and also if they create exceptions to the no vertical rule. Again, interesting to see how the industry develops. I think it's to encourage more players in the market, which is seen to be in the interest of diversity. Folks have a way of structuring around things when they want to. So, we need to definitely keep an eye on that. All right. So I said that the act doesn't really contain much information in the way of what is going to be in the application. However, it does set forth a long list of things that would be basis for rejection. And I lay these out here in some detail because I thought it would be useful for folks to see what definitely will not be allowed. And so anyone owning more than 10% of the applicant has to meet all of these criteria. They have to be at least 21. They have to be a Virginia resident, which is a big deal. They can't have been convicted of they can't have been convicted of a crime of moral turpitude in the past 7 years, or if it was before that, not completed all terms of their sentencing. And that should say has not been. In addition, if, as I mentioned, they have this provision here which seems to try to ferret out front operations. If the authority finds that you're not really intended to be the owner and you're there simply because you are qualified social equity applicant, yet the deal's been structured to undermine your authority or ownership in other ways, then that would be a basis for rejection. So they are going to be looking to make sure that these social equity applicants are who they say they are. You also have to be able to demonstrate sufficient financial responsibility, which I find interesting because you have to be from an area that's been disproportionately impacted by the war on drugs, but at the same time, you have to have the financial wherewithal of potentially millions of dollars to set up a cannabis business. So, this is where I guess we'll see how people are able to satisfy the authority. More than likely, social equity applicants will have to partner with financial sponsors and manage that relationship in order to meet the requirements that the authority lays out for us in the regulations. So we'll see. But sufficient financial responsibility is what they say they're going to be asking us to show. You also, let me go back. You also can't have had any misrepresentations, obviously, or fraudulent filings with any government authority. They will go over your applications with a fine-tooth comb. And if they ask you to disclose all misdemeanors, then you better disclose all misdemeanors, etc. So there's a variety of things that are in the application, some of which you may not want to tell anyone. And it's always better to disclose, because in my experience, the authority will find out. And if you did not disclose it to them first, then they will say that you are disqualified. So I think it goes against your own inclination to report, for example, bankruptcies or criminal activity. But remember, this is a law that is supposed to rectify some of the historical imbalance in enforcement of criminal laws, and therefore having a crime on your record is not necessarily a bad thing, but lying about it is disqualifying. So that's very important. Also, police officers that patrol the area where the licensee is to be located, they will not be eligible. And then if you're a manufacturer, distributor, or retailer of all alcohol or tobacco products, you will not be eligible for a license. In addition, licensed locations are going to have to meet certain community guidelines and requirements. So they will take a look at the location. They will see if it's too close to a church or a hospital or a school or a daycare facility. So when you all are looking for locations, you're going to want to be mindful of what the law requires in terms of distance away from these types of facilities, because you will not get the required zoning approvals if you are not where they say you can be. You also can't be in a location where you would adversely affect residential real estate values. So if you're substantially interfering with neighbors' quiet enjoyment, then that's a basis for rejection. You know, if you're a cultivator, smell can be viewed as interference with neighbors' quiet enjoyment. So if you are looking to obtain a cultivation license, then it would behoove you to locate it somewhere where you're not going to be bothering people in their homes, because that could be difficult for you if you are. Also, stores cannot be within 1,000 feet of each other. So initially, not a big deal, but as the program matures, the real estate that qualifies will start to not be available anymore. So it is important to think about these things. And like I said, the regulations will have a lot more detail on exactly what you can and cannot have in a location or in an owner of your business. And being that it's heavily regulated, every owner will have to subject themselves to a background check. They will have to get fingerprinted, and they will have to be subject to the scrutiny of the authority. If they commit crimes, they could be asked to divest. So there is a variety of things that go with being an owner of one of these businesses that's not typical for businesses and that some people may not be comfortable with. So keep that in mind. You know, the process for applying is an interesting one that I'd like to spend a little bit of time on, because I think a lot of people really underestimate the effort required to win one of these licenses. And your competition in this effort is experienced and well capitalized. So it's very important that you come at this with a plan and that you allocate yourself enough time and resources to put together a real competitive bid. So in this case, we don't know the timing yet. That will all be set forth in the regulations once they come out. We do know that legal adult use sales are expected to begin on January 1, 2024. Now, a lot has to happen before that. They have to write the regulations. They have to publish the application. They have to give us a time frame for submitting the application. The applications will have a variety of requirements, which we will talk about here. And once that is submitted, then the authority has obviously a period of time to review the applications, to score the applications, and ultimately to decide on the winners. And then a period of time for those winners to get open. Now, presumably, anyone who has an existing cannabis business will have a lead in that process because they're already operating. But nonetheless, January 1, when you think about how much has to be done before January 1, 2024, you realize that really is not a whole lot of time. So I expect that they are writing furiously to get this process going. So the authority will write and publish these regulations, and when they come out, anyone who's interested in applying should print them immediately, cover to cover, and put them in a binder, because that's your new Bible. And you will need to read every line of that document and understand every line of that document. And ultimately, your application is going to have to reference in one way or another that you understand the requirements of that document. So it will have details in terms of how you need to operate your business, what needs to be in the application, what needs to be in your business plan, what needs to be in and around your location. What types of security requirements do you need? How are you going to track and trace the product, and all of the various requirements that go along with regulation and enforcement. So there is a lot of work to do. It's not unusual for an application to be hundreds of pages long, and include not only the items that are required, such as the business plan or the security plan or the inventory management plan, but also community support letters, local commission letters from local commissioners saying that they support your effort, local businesses saying that they support your effort, information on exactly how you're going to pursue the goals of diversity and inclusion, and what's the plan for that. So there is a variety of work that goes into putting together a competitive application. And I have to say, just to be fair, in the interest of full disclosure, that a lot of the big boys are spending a lot of money on this process. So it's not unusual for someone to spend $500, $1 million on putting together an application. Now, does that mean you have to spend $500,000 or $1 million? No. People win all the time on applications that they do themselves, but they're good. They're very good. So it definitely is something where if you you're going to need the right resources around you in order to succeed in the process. So talking on that a little bit more, the applicant must exhibit a detailed understanding of the act, and I can't underscore that enough. So that's why I said print it out and read it again. The authority more than likely will check your application to make sure that you have touched every point that's in the act and in the regulations. And so, I think the compliance aspect of this type of business is much greater than you find in other businesses. And having someone on the team that really understands the law is going to be an important part of a winning effort. More than likely, the process will involve assigning points to various parts of the application. So say 50 points for your security plan, 50 points for your diversity plan, 50 points for being a social equity applicant. Now, I don't know what the points will be. That will be in the application when it comes out. But the important thing is you got to get all the points. So if there are 5 points that are given to veterans, then you need to get a veteran. You can't leave any points on the table in these efforts, because lots of people will show up with applications, and a lot of them will be really good, and some of them will be perfect. And there have been efforts in other states where it's literally tenths of a point that differentiate winners from losers. So we don't know the details of Virginia's process, but I think we know enough to know that it's going to be very competitive. And so please read that application, really understand where all the points are coming from, and then get those points. It's critical. At this point in time, we don't know what benefits will be awarded social equity applicants. The law does high level indicate a few things, such as this fund will be available to them. There perhaps will be reduced application fees involved, and hopefully points will be awarded for qualified social equity applicants, so that they do have a bit of a leg up in the process. Now, depending on how many points are awarded for social equity status, it may be that you can't win without being one. And the reason I say that is because if that is ultimately how the law is written, or if social equity applicants are given some early mover advantage in terms of when they can apply and get going, then you're going to see a lot of activity around multi-state operators from other states trying to find qualified social equity applicants that they can partner with. And I think I'm going to talk about that because you may get those calls. you may get those calls, and you should, I think, be ready for them, because in a lot of times, it sounds great, but it ends up not being what you expected in that situation. On the other hand, it could really help you finance this effort. So those relationships have to be managed carefully. And depending on how the law is written, you could find that there's an intense focus on finding qualified social equity applicants, so that multi-state operators can get winning licenses. Now, again, because there's no vertical, that dynamic could be different in Virginia. New York is also rolling out a law that does not allow for verticals. I believe both of them are first in the I believe first in the nation for doing that, and their processes are so new that people haven't really seen how that affects the industry at large long term. So it'll be interesting to see how that unfolds, whether you have a lot more participants in the industry on account of that, and whether it does really end up promoting the business, as well as policies and goals related to diversity and inclusion. All right. So, parting thoughts. Even when drafted with the best intentions, the implementation of cannabis social equity programs have been plagued with problems. And I think it's important to kind of note that at this time, because things often sound great in the beginning. When the regulations come out, they look very progressive. Illinois was this way. The law was very focused on social equity and seemed to very much favor the expansion of diversity in the industry. And then once the program was rolled out and implemented by the state, it really did not end up with the results that folks intended. And as a result, there was huge upset. There was protest in the streets. There's been litigation, and the licenses, none of them have been awarded. They're all held up in litigation. And so what started out as being maybe the best law that we had in the way of diversity and inclusion in cannabis has turned out to be one of the worst states for that at this time. So even though the laws are written with the best intentions, the implementation can make the whole difference in whether the goals are actually achieved. I put Maryland here, being a state that I've been involved with quite a bit, and Maryland as well. Huge efforts on in helping the industry be diverse. Initially failed, had tried to come back at it again, still plagued with difficulties in terms of the process, and folks tied up in administrative hearings and litigation, and not really able to get their licenses going. So hopefully that is not the case in Virginia. Hopefully Virginia will learn from what's happened in other places and roll out a law that does achieve what it's intending to achieve. And we'll really just have to wait and see if that's the case. And as I mentioned, it does have this feature similar to New York that limits industry consolidation to allow for more business owners and competition. That can be great for diversity and inclusion, but we'll see. Folks are very creative. Take it in my line of work. Folks are very creative. Also, highly capitalized MSOs will continue to use every loophole to qualify for and win licenses. So if they can structure around the no person owning more than one license, they will. And if you are a qualified social equity applicant, I say be prepared for their call, because I believe you could get one. So that pretty much sums up where we are with the law now. I think, in a few months, when the regulations publish, we could do a entire new version of this presentation that puts a lot more detail, because it will have then been written. But I do think that this is giving you a nice overview of where things are headed. My advice to anyone on this presentation that wants to get a license: get started now. Scout out locations now. Get your team together now. Don't wait till the regulations are written. Get going. Start on your business plan. Get it together, because that's what folks are doing. So you're already late. so to speak. So please do, find your team and strike out with the vision, and hopefully you'll be successful. In the meantime, if anyone has any questions, we'll be taking a Q&A after this session. Here's a little bit of information about me. If anyone wants to reach out with questions, happy to answer them as you all move through this process. Thank you so much, and I appreciate your time.